morning. My name is Rebecca or Becky Orff, and I'm currently the staff attorney for Jcip, which is the Juvenile Court Improvement Program that's part of the Oregon Judicial Department. And it's really my pleasure to welcome you all to this training today. I think you know, or if you don't, it says on your booklet, this training this morning and the session this afternoon for all of the community stakeholders is a joint effort between the Judicial Department and Child Welfare Department of Human Services. And so in just a minute I'm going to introduce our training team. But I did just want to say, I just started this job the 1st of February of this year. Those of you who know Timothy Travis, I'm Timothy. So if that clicks for you. Except I'll never be as entertaining as Timothy was. So you'll just have to bear with my boring presentation maybe as compared to his. But prior to taking that job, I sat on the bench in Jackson County for 14 years. And before that was an attorney representing children and parents as in child welfare cases in Jackson County for about 17 years. And so just to give you that background, and I'm really happy to see you all here. And let me just start out, I know our DHS folks, most of them I heard are in a staff meeting, are going to be coming in a little late, but other DHS folks here? Oh great, so we've got, and how about CRB? We got any citizens? Great. CASAs, attorneys, yes, good. And judges, I know we have Judge Ticton here. Oh, good, great, great. We've got 2 of our judges here, so that's great. Who did I leave out? Did I leave out anybody? Court staff. Yes, thank you. Courts wouldn't run without our staff, so I almost forgot that one yesterday. It was, all right, well, let me briefly introduce our training team to you, and I just want to say this is a great group of folks to work with. And this is our 4th roadshow presentation. We were in Burns yesterday. Where am I? And we've been in Astoria, McMinnville so far. So just to tell you, you do have evaluations. And we'll remind you again, please, before you leave today, fill those out for a couple of reasons. One is we have 8 more roadshows to do. And so your comments could help us improve those subsequent roadshows. The other thing is that this training is being paid for by our Juvenile Court Improvement Program grant, which is federal funds. That's why we're still able to do this training today. And for that grant, we have to have these evaluations. But the most important reason to do them, really, is that we want your feedback on this training. We probably will be back doing this again next year. And if not next year, certainly after the 2011 legislative session. And we really want to know what we could do to improve this and to make it a better training for you the next time around. So please take the time to do that. Also want to just let everyone know you are being recorded today. We are videotaping these sessions today, and so that we can post them on the Jcip website. For those that were not able to travel to one of the locations, I know that much of the training and if not all the travel money has been restricted because of our respective budgets this last time around. So just to let you know that you will be recorded, and if there are comments or questions, these mics aren't amplifying, they're feeding into the video this morning, so I hate to do this, but I need to kind of have you come up to the mic if you'd like to ask a question so we get that on tape for those who will be viewing it. So let me introduce quickly our team that's here. First, Marita Johnson from DHS. Marita is in charge of seeing that our state and Oregon complies with the program improvement plan that I think most of you know, but just briefly if you don't. Much of the money that child welfare receives to do their work comes from the federal government, and as with all federal funds, there are strings attached. And so there are a lot of performance measures and things that we need to do to make the system better for kids and families. And so periodically the federal representatives will come in and do their child and family services reviews, CFSRs, And then and they'll go around monitoring what's happening with the courts and DHS, and then they put together a performance improvement plan that we have to all work together to accomplish for child welfare to continue to get funding to do this work for children and families. And so I call Marita the PIP queen. So seated next to her is Sherry Mason. Sherry has long been with our Citizens Review Board. She just recently joined the Jcip team. And we're really excited to have Sherry on board. I think we're going to start working towards much more coordination between the court and our CRBs. And Sherry also is going to be talking about our Jcip model court effort, and she'll be our contact. So if you need some help with your model court efforts in your counties, Sherry will be the one to give you some technical assistance. Seated next to her is Jan Slick. Jan is also with DHS Child Welfare and in charge of their home-based services programs. And then last but certainly not least is our next speaker, Mickey Cerise. Mickey is also with Child Welfare in the central office, and Mickey, your official title is?
Deputy Assistant Director.
Deputy Assistant Director. So I do want to say, you know, as a trial judge, I often sort of wondered what happened in Salem. I had a joke about this, but since we're being videotaped, I won't use it today. But, you know, I often wondered what happens in central office. What do they do at DHS central office? Well, I have to say, since February, I have been at DHS central office a lot for various meetings. They're great partners in terms of collaborating with the Judicial Department. And I have just been so impressed with what a wonderful, dedicated, hardworking group of people there are in central office at DHS. So I just want to put that plug in for them. So without any further ado, I'm going to turn this over to Mickey Cerise. Mickey and I both were working on legislative issues for the Judicial Department, myself and Mickey for DHS this past session. And being my first legislative session, it's amazing to me how I could go through law school and be a judge for 14 years and really not get it about how a bill becomes a law. And so it was quite a challenge for me this last session, and Mickey was wonderful help, was a wonderful collaborator with Judicial Department, helped with getting data. Part of the jobs that we do is to prepare what are called fiscal impact statements for potential legislation. So we were sharing a lot of data back and forth, and I've really enjoyed working with him. And so Mickey's going to start out talking about the new legislation that passed. And so Mickey.
Great. Thanks, Becky. And I see we have a number of new folks coming in, and you must be with DHS? Is that because we heard you were in a meeting? And good. So I'm going to talk very briefly this morning about legislation that passed this last legislative session. And in your packet, you may have two of them. The one that's entitled Agenda and Table of Contents, I'll be talking about the first 3 pages. And that's going to be fairly unique. Those of you that have seen the Legislative Roadshow presentation in the past will notice a couple of things. Becky already mentioned one. Timothy Travis is no longer here, and where Becky is filling in for Timothy, I used to be Timothy's second. So when Timothy would have his jokes, they went nowhere without me. I set them up for him. So, and I'll do the same for Becky after we get on a roll. It takes about 5 or 6 of these before we understand each other. The other thing is that the legislative roadshows in the past had hours of presentation around the legislation that passed the past legislative session, and we went over those in great detail. And you're going to find out that we don't have that much legislation that passed regarding child welfare this time. And one of the reasons that happened was a little thing called the economy. And as you know, going into the legislative session, the economic forecast, the budget picture began to look bleak and even got bleaker as we moved through legislative session. So quite frankly, the entire conversation with the legislature was around funding and how are we going to maintain those services that we have currently in place. And very often when a bill is put together, there is also a recognition that it's going to cost money to implement the concept in that bill. That's called a fiscal impact. And going into this legislative session, if there was a bill that had an obvious fiscal impact associated with it, that bill either did not move at all, we did not hear the bill in committee, or we did hear the bill to have the policy discussion only, but the bill was not going to move forward. So where in the past, the last 3 legislative sessions before this past one, child welfare in DHS tracked about 400 bills on the average of each of those sessions. This last session, we tracked 200 bills. So it was a easier workload in terms of the bills that went through, but there was almost 4 times the activity of the interim and behind the scenes work groups that were taking place with the legislature, not only around the budget, but child welfare and self-sufficiency. Those 2 program areas in CAP are huge items for the legislature. And of course, we're only going to talk about child welfare in this presentation today. So I'm going to go quickly over a few bills. Please, as I go through this, if you have some questions, raise your hand and just ask me before I go too far beyond that. It might be the better way, I think, to do it. And
maybe you could repeat the question if folks, instead of asking folks to climb over one another to get to the
okay.
That'd be great.
That'll work for me if it'll work for, yes, okay, I got a head nod back there, so we're good to go. I put the bills that we're going to talk about today into 5 different themes. And the first theme, very simply, is mandatory reporters. And this legislative session, we have added 2 mandatory reporters to the list of mandatory reporters in the Oregon statutes. So we now have pharmacists and we have Teachers and Standards and Practice Commission. And the Teachers and Standards Practice Commission is a group that works with the Department of Education around investigations of teachers when they have reports of misconduct with students. So for about the last 4 or 5 years, there has been a lot of conversation in the legislature with the Teacher Standards and Practice and the Senate, actually the Joint Education Committee, on what the Department of Ed needs to improve their ability to protect students. This was one of those pieces of legislation they wanted to move forward. So they wanted to become mandatory reporters. Very good show of faith. Now I'm going to move pretty quickly into the CPS record sharing, because you'll notice in that, in Senate Bill 123, we again have the Teachers Standards and Practice Commission. And this was the second part of an idea of a concept that they had going through this legislative session. And this bill allows that investigative arm of the Department of Education to request child abuse records from DHS. And then we would provide those records when they are looking at a teacher if they believe that that teacher may have some misconduct going on with a student. And right now, we don't have a procedure in place, although you will notice that this particular bill went into effect June of '09, so it's in place now. So if any of you at the local level in DHS receive a call, you will want to call Stacy Ayers in central office. I told Stacy I was writing his phone number on every bathroom wall from here to Burns. So it's his number is 503-945-6696. Stacy and his team will be writing some rules on how we will want to handle this. But first, we want to see what the numbers look like. In the conversation around developing the bill, both Teachers Standards and Practice and DHS believe these will not be large numbers. However, we don't know what that impact will look like because they're dealing directly with DHS. What we don't want to do, because the bill is in effect, is create any obstacle for TCB, for the Teacher Standards and Practice Commission. It's going to be a new acronym I have to learn. We don't want to create a barrier for them. If in fact they're investigating a teacher, they need that record, we want to get it to them right away. So if you have the record, don't know what to do with it, call Stacy and we'll walk you through that. The second entity that is accessing child abuse information, not records, but information, was put in statute and called Metro Service Districts. And this bill was actually introduced by Portland Zoo. And Portland Zoo approached a number of entities. They actually approached the Department of Employment because they handle a registry of child abuse offenders for their daycare portion of their programs. And they approached the Department of Employment and said, we have these volunteers that we hire in the summer. These volunteers work with up to 4,000 kids in a summer, taking them on tours, doing some shows with them, and we need a mechanism to be able to call someone and say, we're hiring John Doe. Do you know if John Doe has a sex abuse background? And made sense to everyone, and so there was some funding attached to this from the Department of Employment's perspective. It did have a fiscal impact. Metro Zoo put the money up, so it didn't come out of general fund. So it's one of the few bills that had a fiscal impact that did pass this session because we had other funding that came into it. This should not affect any of your field offices. The call should go directly to the Department of Employment. You may get a call at some point down the road, and if you do, they'll be referencing this bill. Again, Stacy Ayers would be your contact if you have any questions. But we can't envision any reason why a local office or the central office in child welfare would get this call. But two good bills right there to help us protect children. The next area I want to talk about is relatives. And I'm going to mention two bills that passed this last legislative session, but then I also want to talk a little bit about what is going on behind the scenes with this idea of relatives and our child welfare system. And I'm going to start with that second bill that's listed there, House Bill 2897. This bill is one that requires that when DHS has a foster child, and we recommend that that child be placed with a relative, and the court decides not to place with that relative, this bill requires the court to list the reasons why. This was based on a single case, and we were asked to do a survey to see how many of these cases may exist statewide. We did an anecdotal survey, an informal survey, over a 2 to 3 year period, and we came up with 2 or 3 others besides this one in the state. So we don't think this happens very often, but it is a bill that passed. And when Becky mentioned earlier that you can work as a judge and know the law, but looking at how those bills are formed sometimes is a real eye-opener. And a lot of times bills are based on one-time instances, and we think this bill kind of went through based on one case and right timing, and so it came through. But we do not think this will have a large impact on either DHS nor the courts for that matter. House Bill 2050, this bill increases from 6 months to 12 months the amount of time it will take for a non-relative to become a caregiver. That's the term that's used in statute. And in DHS, that translates into our current caretaker policy and rule. So right now, a non-relative can become foster parent. A non-relative foster parent can become a current caretaker after being with that child for 6 months. When this law goes into effect, which would be January 1st of 2010, that rule, that statute and that rule will change, and that current caretaker would need a 12-month period of time before they can qualify. This is, even though this is a simple bill, this bill has actually floated back and forth over the years. I think it originally started off 18 months, went down to 12, went to 6, and now it's back up to 12, you know, and trying to figure out where that magic number is. And right now, there is a lot of conversation taking place in the legislature and with the Judicial Department and with the Department of Human Services and how the Child Welfare Agency in Oregon can better work with relatives. And we're talking about how do we engage them quickly, early on in the case, very aggressively, and support them throughout so that if that child cannot return to the parent, that child will return to a relative. Because research says that that child will have a better long-term outcome if that child stays with a relative placement.
If I could just
Absolutely.
add something from court perspective here. As Mickey has been saying, there's a lot of interest in the legislature in juvenile matters that often comes to them from grandparents. And many legislators are also grandparents, and so those stories are often heart tuggers, and that's behind a lot of this. Part of the issue is not only child welfare learning to work better with relatives, quite frankly, but attorneys and judges also learning to do that. And I would suggest that best practice would be, even though grandparents aren't parties, that they get an opportunity to at least be heard in court, and that us judges, and I'll still say us judges, I'm still sitting on the bench some as part of my retirement, need to get better at really articulating the reasons for our decisions, because as you know, the records are confidential, and if we don't say it in court and relatives are there, they often have no idea why decisions are being made. And this is an issue that I can almost guarantee you, and I think Mickey agrees, is going to come back up in the next session of the legislature. There was a bill to make grandparents parties to juvenile proceedings, so those of you who want to think that through, you know, you may realize they maybe would get court-appointed counsel, they would have a right to be heard, they would have a right to discovery and to get records, and you know, parents, I said, gee, wouldn't you like your in-laws reading your psychological evaluation? But just to tell you, I really anticipate that something similar might come up this next session. And if we all don't do a better job of engaging relatives in decisions about children that we're dealing with, then we're going to have some legislation imposed on us that will require that. And so this, you're going to hear a lot about relatives today. Sherry's going to be doing a session following up on the research behind, you know, we're not just encouraging this for the legislative process. We're not just encouraging it for that. We're encouraging it because research is showing that being with the relatives is often best for children. And Sherry will give you some of that research background just to give you the why this morning. So thank you, Mickey.
Yeah, thanks, Becky. Yeah, so this afternoon you'll go into much more detail about the relative issue and some of the changes the department is making. The final thing I would say about this is you are aware, I'm sure, that we are in the process of revising rules around relatives, and those rules have been going out for comment. I have a list of 65 legislators that want me to send those changes to them for their input. I have about a half a dozen of those that are pretty active in giving us input on feedback on how those rules are looking. So this is going to be a hot topic for through the next session. I'm guessing for the next at least 2 to 4 years for us. So stay tuned. The next area I want to talk about is foster care, and very briefly, Senate Bill 125 is a good bill. It's one that caught us in the middle of session. The Department of Transportation was actually moving a bill through and happened to hear a presentation by a group of very impressive former foster kids who are very successful now, and they were lobbying their own bill, and their bill was around independence for foster care. In that bill was a comment about foster children needing to get their driver's license. They need to have that early so that they can move on to be successful. Their bill did not make it because it had a pretty substantial fiscal impact, and those bills just simply didn't go this session. The gentleman from ODOT heard that, picked the phone up and called Kevin George, who's our foster care program manager. He and Kevin have worked before, and he said, what I can do in my bill is insert a section that says, if DHS pays for driver's education for a foster child, ODOT will reimburse DHS for that cost. So that bill went into effect, or let's see, went into effect June 1st. So if you have foster children and you are paying for their driver's ed, call Kevin George and he knows how to bill ODOT, and then we'll get reimbursed on that. It was the amount of money and what that will do financially is not the issue. What was paramount about that particular interaction, we had an entity we rarely work with, ODOT. We have an entity that grew up this session, 3 former foster kids who did a wonderful job getting information to the legislative committee and lobbying better than any lobbyist I've seen at that Capitol in a long time, and teaming with DHS to make something happen that was positive. So had to mention that one as we went through this presentation. House Bill 3114, we consider this the most substantive bill that passed this legislative session. This is the psychotropic medication bill. Representative Kotek was the sponsor for the bill. She engaged all of DHS, not just CAF, the division, but also DMAP, mental health, A&D, SPD. We all got involved in helping her work the bill to the best possible place without a fiscal impact, because we knew the bill would not pass if it had a fiscal impact. So we came up with this bill that has basically 3 parts to it, and I'm going to go over those briefly. This bill will require a mental health assessment for any child in foster care that are receiving 2 or more psychotropic medications or 1 antipsychotic medication. It also requires an annual review for any child that's receiving 2 or more psychotropic medications. Now, those 2 things almost sound like common sense. If you think about your child, you wouldn't just begin prescribing medication without some sort of an assessment, and I doubt if you'll continue giving that medication unless you had some sort of regular follow-up. So those 2 things not only follow common sense, but they follow the direction the department was headed anyway. Yes, ma'am.
The term assessment is usually used differently than evaluation, and so I'm asking whether that's meaning there's no specificity there. Does this have to be an assessment by a psychological professional, or just anybody who says this is a mental health assessment, and who did it? What kind of standards can we require of the person doing the assessment, and how in depth is that? We say a psych evaluation. We mean by a professional psychologist, or what? Because that's an important difference.
Okay, and I'm going to repeat your question. Just that do we have to be concerned about the quality of the assessment, or to make sure? Yeah, who does that assessment? And the bill, we had a lot of conversations around that, and that went back and forth. Where it settled was your existing infrastructure will work. Whoever you use now to do your mental health assessments, your evaluations for medications, all of that infrastructure will be fine. We were very careful with the language not to do something that would disrupt an infrastructure in a particular county, thinking of another county, because all counties operate just a bit differently. From the DHS perspective, we would want them to be, of course, OHP eligible. From that perspective, does that answer your question? Or I'm thinking you're.
It doesn't put a lot of teeth in that bill, because somebody can send someone to a psychiatric nurse, for instance, and I'm a nurse and I approve psychiatric nurses, but they can write up a little review about this and say, yes, give them the medication. And do we have any authority, let's say as CRB or anybody else, to say this isn't a high enough up the professional ladder to really be a certain evaluation, or as you're describing it, assessment?
Yeah.
Assessments are usually taken to mean somewhat less thorough, less demanding than evaluation. And I'm just saying we're going to get caught in saying to a caseworker, this evaluation or this assessment isn't thorough enough to answer the questions we need answered, and they'll say, well, that's as much, we don't have to do more than that.
Yeah, I think that I believe that your local infrastructure is going to meet this need. If we, on the other hand, are challenging an assessment that we see, I think that's a different category. This is simply saying we don't want a caseworker making that decision on the medications. We want that child to be seen by a mental health professional. If you have a psychiatrist and that psychiatrist is available, that's great. But if what you have in your county mental health system is a triage where that person is first being seen by a mental health professional who then recommends to a psychiatrist, I think we're going to be, that fits this law, that fits the law.
Just one suggestion to bring up here. If the CRB, for instance, feels that a child needs a full-blown psychological and can articulate the reasons for that, CRB can certainly recommend and encourage the attorney for the child to apply for indigent defense funds to pay for such a psychological. And so attorneys in here, I think we have at least one or two, hear that, and CRBs and CASA encourage your children's attorneys to follow through with that.
So the third piece of this is that when a medication is prescribed to a child, it has to be prescribed for what the medication is indicated, what the medication is designed to do. So, for instance, the example I've given before is in years ago, it used to be a drug called imipramine would be prescribed for children who had depression. But a side effect of imipramine would also help them with bedwetting. And so it wasn't unusual if a doctor knew that a child was a bedwetter, was encopretic, that they would prescribe imipramine in hopes that that side effect would correct the bedwetting. That medication would not be indicated for bedwetting. It would be indicated for depression, but the child doesn't show depression. So this language in this bill says we can't prescribe that medication. Now, all of that said, Terry Schultz, you may know her, she's our the consultant nurse that we have in central office, is putting together some training on this. Like I said, this was the most important bill that we saw going through this legislative session. And we have pulled together a number of divisions within DHS to make this work as smoothly as possible. Terry is planning, I think she said it's a 3-hour training that will roll out by the time the bill goes into effect, which will be June of 2010. Representative Kotek recognized that we needed to put some things in place before the bill actually goes into effect. So I would do one of two things. Either go ahead and call Terry, let her know you're interested out of Deschutes County to go to the training, and when does she think it will be coming to your area? I think she's starting to list that schedule, or at least tentatively work up a schedule now. The other thing I would suggest, I asked Terry if it was going to be mandatory reporting, mandatory training, and she wasn't sure whether it was going to roll out that way or not. I would strongly suggest that caseworkers and clinical supervisors attend the training that Terry puts out. This is not only important for this legislation and for our foster kids, but this ties into so many other initiatives that we have going on regarding the well-being of children and their health issues when they're in foster care. You know, for instance, the mental health assessments that need to be done within 60 days. Yes, ma'am.
When you say monitoring, what does that mean in the sense of, is that monthly, is that weekly, is that biannually, I mean, every 3 months, quarterly?
Yeah, the monitoring is annually at this point.
Well, I see an annual review, but monitoring I see is different.
Okay. Oh, I'm sorry. The monitoring, I don't know if it's going to be quarterly or not. I don't know if it's going to be quarterly. That is still left to rule. I do know that the group, and I'm going to forget their name, but it is a group of physicians with the DMAP division have agreed to do our monitoring. And the monitoring would have to be done by a physician who is not a prescriber of that medication. But what I don't know is the frequency of that. Well, that would be my thought, is that it's at least annually, but I don't, it seemed like there was in the original bill a number, and that created a fiscal impact, and so they left it silent, which means we can put it in rule. And it will be in rule. The last big area I was going to talk about on the legislation is adoptions. And this session, there was a focus interest in the area of adoptions, and it was around international adoptions. 2 bills passed. They basically are the same bill. They just split them as session as they began to create the concepts. Senate Bill 10 basically says that the Department of Human Services will write rules around international adoptions, placements of children in other countries, and how to work with the Hague Convention. So pretty straightforward. House Bill 3471 then tells the department that as you're writing those rules, you'll make certain requirements of those countries based on the safety of the child. More specifically, we want you to require certain things around supervision of that child once we place the child in a foreign country. So we want visitation with the adoptive placement, with the adoptive parents, with the child. We want visitation with any adult that might be living in that home that's not related to the child or distantly related to the child. We want visitation with other significant people in the child's life who may not be related. So teachers or doctors or ministers or neighbors, to give a different perspective, and all of that fold into a report that we would receive to assure that the child is safe once we make a placement. Now the issue that we ran into early on with this in conversations with the legislature was whether or not doing this could be perceived by the international community as us delaying permanency in placing a child with a relative who lives in another country. And we engaged the Department of State in a number of conversations with us, and the bottom line was no, we would not be perceived as creating a barrier. That all we're doing here is what our federal law says we must do, and that is we're considering safety first. We're considering this is the bare minimum for us to say that a child would be safe, a child in our custody would be safe if we place that child in another country. We would at least have these minimum expectations for that country to do for us to let us know that that child is safe. Yes, ma'am.
I'm sorry, but how do we acquire that information from a foreign country? You're going to send somebody down there to check it out? Or are you going to rely on the local social services or child welfare programs in, say, a small village in Mexico?
Okay, the question was how would we rely that we would get that information?
Exactly.
Yeah, and there is a process in place right now. We use the consulate in a foreign country to use their social service system to provide this work.
Our council, American.
Well, the foreign consulate. So if we're dealing with Mexico, we're dealing with the Mexican consulate. It's not ours. Would be
no one from our embassy or our official people there check it out.
Right.
So you're relying on the local authorities and what they tell you.
Right. That would be practicing social work in another country. We cannot do that. You can't even do it across state lines.
And Mickey, I think you've discussed before that in some countries, if that process, or even in parts of countries, is not satisfactory to assure Oregon child welfare that this child will be safe, then that placement might not happen.
Right.
If they can demonstrate that it would be.
Yeah, that's the purpose for making this requirement. The other piece that we think would happen is if a country says, yes, we will do that, we send a child there, and that doesn't happen, we view that as reason for us to bring the child back.
And you think you could give it back if the family didn't want to give them back?
Well, we would have jurisdiction, yes.
Somebody gets a trip to Mexico.
Well, but you know, the issues that you're bringing up right now, we deal with all the time when we place children out of state. That is us dealing with another country.
Different than out of country.
Well,
Because out of state, at least they're operating under the same basic laws as we are. They may not be.
we're dealing with out of country now. There is no guarantees, and we do send workers out of country all the time to place children, to pick children up. Sometimes we have a court order to actually go and do a visit with the child. So we're already doing a lot of this. Some of the practice pieces won't change very much. This is just a stronger guideline in when we would say, yes, let's send a worker in to go do something. And we always work through Department of State and the consulate before we make any moves. So,
How many children do we have in this situation?
Yeah, how many do we do
per
a year?
oh, there, let's see, total, maybe less than 30.
Annually? Each year? About 30 a year?
No, that's total at any given time. That's a point in time. We have, I didn't bring the stats with me, we just had this presentation with the legislature. We had, in a 2-year period, about 13 children went to Mexico. That was the largest country. We had another, I think it was another 10 or 11 kids that went to, maybe 10 other countries. So there's not a high volume of these, but they do take a lot of time because we find out that even our legal system is having some difficulties with the Hague Convention recently passing new laws in April of 2008. So some confusion. We have, those of you in DHS know that we've pulled together a diversity unit within CAF administration. I supervise that unit. Gloria Anderson is the manager of the unit, and we have Oscar Herrera. And those two people, Gloria Anderson and Oscar Herrera, are people that are trying to pull together all of the issues involving foster children and international affairs. And what we're trying to do is to create a central point where we can provide consultation and support when we need that. At last count, we had, this was about a year ago, we had about 160 identified international cases on the records. Not all of those kids are going to another country, some of them are, but all of them require some interaction with the consulates that are involved, some interaction that's a little bit different than the norm of practice. So it's almost a little specialty area that's beginning to form out there, and we're still trying to get our hands around all of that. Some of you may have experienced recently, if you've asked for visitation for a foster child to another country, our office refusing because of threats of the H1N1 virus. You know, for a while there were pockets in other countries that were not safe to travel. There were other issues. There were some drug wars going on. This was all over 60 Minutes. And Gloria and Oscar were on the web pages every time we would get a call, checking out that city to make sure it was okay to travel. It didn't have a warning preventing foreigners from coming in to travel. Sometimes they could say yes, but at the same time you had to enter through a different portal. So actually went a little bit longer than I wanted to, so I'm going to point to you the last page where it says general. Those 4 bills don't have any impact on you directly, but they are interesting bills, and as you kind of look through them a bit, if you have any questions, I'll be around to answer your questions. And thank you very much.
I just wanted to follow up real briefly with 2 bills, and these mostly, I'm not going to really explain this. If you'd like to talk to me at a break, please, because this is mostly for the legal minds in the audience. I wanted to mention Senate Bill 270. Senate Bill 270 involved a legislative fix, so to speak, to a recent Court of Appeals order in a juvenile dependency case. And in that case, the Court of Appeals looked at the statute and correctly noticed that confidentiality of juvenile records only applied to juvenile courts. And the Court of Appeals is not a, quote, juvenile court. And they got a request from the Oregonian for some information from the Court of Appeals files, and there was a decision rendered saying what I've just told you. And that created a lot of concern amongst a lot of us in this area. And so Senate Bill 270 basically provides that records of juvenile proceedings are confidential on appeal to the same extent as they are in the trial courts, except appellate decisions will be issued. So they do issue appellate decisions, but if any of you are reading those, you know they're now using letters for the parties' names, so it's impossible to remember cases. You know, you used to remember Smith versus Jones, but now it's AKJ versus GWC. So, you know, but it's out of that effort. I do anticipate that confidentiality of juvenile records is going to be a legislative issue potentially. I've been in a couple of work groups talking about this. I know the Oregon Law Commission is going to be looking at this, and there is a big interest in trying to open up juvenile records by the press, particularly the Oregonian and the American Civil Liberties Union, because they've been attending these work sessions. So hang on, there'll be more happening, I think. Senate Bill 262 changes the level of review by the Court of Appeals in reviewing dependency cases. In the past, it's been what's called de novo review. They look anew at the case and make their own factual determinations. This bill says that the Court of Appeals, in its discretion, can decide to choose whether the review will be de novo or whether it will be what we call looking at substantial error in the record, that kind of thing. The one exception is that all termination of parental rights cases will continue to have de novo review. So I'm going to end that. We're going to shift to our safety decision-making session. And Sherry and Jan will be presenting this. I want to just make a brief sort of introductory comment, and really this is my piece of this, even though you see otherwise on the agenda. We, in coming to the decision to present this subject, had the discussion about the Oregon safety model. And I sort of hesitate to even say that because, quite frankly, I think that our experience with the Oregon safety model, for many of us, has not always been positive for some very different reasons. Part of it, and child welfare will readily admit that the way it was rolled out was not ideal. In fact, the first time I heard of the Oregon safety model was in the courtroom from a caseworker. We had no training as judicial officers that it was going to be implemented. We were told it was implemented. And also, I don't think some caseworkers really were fully trained on the safety model before it was implemented. So I was having caseworkers, quite frankly, tell me sometimes when I disagreed with where they were going in the case that, oh, it's the safety model that made me make this decision, Judge. And I would go, well, then I don't like the safety model because that's a bad decision. And I had a really interesting experience just quite recently. I was in Washington, D.C. in June at a National Court Improvement Program conference. And the big talk was the, do you have it with you, Sherry? I could show it now. The Child Safety Guide for Attorneys and Judges, a handbook for judges and attorneys that had just been printed by the American Bar Association. And so Timothy Travis was going to be talking about, he wanted to talk about this. He knew it was coming at our judges conference in August. And so I said, great, Timothy, come talk about it. And then I picked up this book at the conference. I started looking through it, and I went, wow, this is really great stuff. This really gives some structure around my decisions as a judge about how I figure out if a child's going to be safe. So I called Timothy. I said, Timothy, this is great. This is great. And he says, yes, Becky, that's what the Oregon safety model is based on. Oh, you're kidding. So I think there's been a lot of, I'm confessing to you my lack of understanding and appreciation for the safety model. And also one thing we've heard, well, child welfare changes their processes all the time. So when's this one going to go out? Well, just to say, I've always said that to be involved in the child welfare system or the juvenile dependency legal system, you have to be ready to adapt quickly to change. You have to be flexible, and you have to be willing to roll with the punches. And if you're not, you're really in the wrong field. There's not a day I walked into the juvenile courtroom that stuff didn't just sort of bounce off walls that nobody had ever heard of before, and we're there shifting our gear, in the middle of the hearing. And also, if you read any scientific research, particularly brain development research, you know that this is an incredibly growing field, that the research is exploding right now as to child development, brain development, those kinds of things. And we will not do our best job for children and families if we don't try to stay on top of current research and best practices as they're rolled out. Are they perfect? No. Will we ever have a perfect one? No. But if we ever stop trying to improve our system, then we've lost. We've lost children, and we're going to lose children and families. And so I just want to say, I really appreciate this. Now, we gave all the judges a copy of this, but it cost about $22+ a piece, and we just didn't have the budget to do that. And the ABA has reproduced this book on their website, which is in your materials, and so you don't have to pay for, you can actually go download a copy of this. The one thing that's not provided to you is the bench cards that are in here, and we have reproduced those, and that's in that other packet of information for the afternoon. And the reason we're giving you this is a great guide, not just for judges and attorneys, but for caseworkers, CASAs, CRB, and everyone who works in the child welfare system. So having said that, I'm going to turn it over to Sherry and to Jan.
Thank you, Becky. Some of you will recognize me from being here last year in the roadshow. We came out and talked then about the interface between the Oregon safety model and judicial juvenile court processes. We're back again. At that point, there was a work group, the Oregon Safety Model Legal Issues Work Group, that was trying to put together where there was a good interface between the safety model and judicial processes. And then we went on hiatus waiting for the bench book. It's here now, and as Judge Orff said, we're quite excited because we think it's a really useful tool in helping all of us to understand the safety model and how to make good safety decisions for children. So what we're going to talk about this morning is, again, about juvenile court processes and how they fit with child welfare processes related to the safety model. To look at where things align well, where they don't align well, and to invite you within your communities, within your counties, to look at what local venues you have to talk about processes and to try to resolve the kinds of issues that you're running into with the Oregon safety model when it comes to juvenile court practice. So, and also, Sherry has now taken on the role of working with with the model court teams. So she's going to be talking more about technical assistance and support that they can provide. We also want to talk a little about whether, in fact, we need statutory changes to better move ahead court processes and working toward child safety. So that's essentially what we're going to talk about in the next hour. And Sherry, I think you're the next piece, and I get to go take notes for you.
I'd just like to do a survey of everyone here. Is everyone here from Deschutes County? Are there other counties represented other than Deschutes? Would you raise your hand, please? Which counties are you from? Jefferson? Crook. So we got Crook, Jefferson, and Deschutes. Anyone else? Okay, great. In those three counties, do you have a model court team? Or maybe you don't call it a model court team. Do you have a team of folks that get together to discuss dependency issues that maybe has representation from the courts and DHS and and from your local attorneys and CRBs and CASAs that get together and discuss some of these issues?
Yeah, Deschutes County does, as a matter of fact. Dr. Tickton is here, who implemented the Family Court Collaborative team.
Okay, great.
The Family Court Coordinator.
Okay. What about Jefferson?
We're working on it. We've met and talked about some ideas, but we're still in process. So.
Okay. And Crook?
Same court system, so it's Jefferson.
Okay, Jefferson and Crook are together. Well, I'm here to offer my assistance to you if you really want to get something started and if you need any ideas or any assistance or help, because we really do believe that the model courts teams, or whatever whatever your team is called, are the place where we need to be coming together to discuss these issues so that we all speak the same language. As we go through the presentation, you'll see that court language is different than the safety model language, and I think there's been some confusion just based on the differences in language. And if we're really going to make these processes work, they're going to have to be individualized to each county, because each county court is a little bit different. Each child welfare system is a little bit different. So for us to get up here and give a statewide presentation and say this is the way it needs to work everywhere would not be helpful. What we really hope to do is to give you a basic understanding and to post some questions for you so that you can go back and meet within your own local teams to discuss how this model is being implemented locally and what you might need to do in order to make it work better. Have you noticed anything that has become problematic in implementing the safety model in your counties? Mm-hmm.
One problem I found is if we are truly doing the protective capacity assessment, the way it's outlined in the book, and we have a parent that's resisting juris, then it's really hard to engage in that protective capacity assessment until after we get juris.
Yes.
And we used to do juris and dispo pretty close together.
Right.
But I don't think that that's benefiting us. I've had a couple recent hearings where I've just had to come to the court and say, I'm not ready for disposition, or throw something that's, with some complex safety issues, that's been an issue.
Yeah, I think the timelines, and that's one of the things we're going to discuss, there are some inherent differences in the timelines that make it difficult.
I think the main difference that we see in terms of disposition is the Oregon safety model is focusing in on outcomes. What's the changed safety versus what are parents doing? And so there's a different focus, and the court orders tend to focus in on what are we asking the parent to do.
Right.
And that's oftentimes, like Damori mentioned, there's incongruency between what we ask them to do and what we really do want from them. Because what we want is enhanced safety,
right,
not them to do something. I mean, if it is enhancing safety, we want them doing that, but there's an incongruency there sometimes.
Right. In an ideal world, when I'm going to disposition, I've done the protective capacity assessment, and I'm presenting to the court my expected outcomes. Versus, I want this parent to go to 6 months of counseling. Well, that may or may not be what produces the desired change. I would rather be presenting my expected outcomes in a 333 and have the court order that this parent change and develop this capacity, and then order that they do any services recommended by DHS. That way I can change in midstream. I don't have to wait till we go back to court and say, hey, this counseling isn't working, but we found this great, class or is really working well to do parent training in the home. So.
Okay. Other issues? Okay, we're going to talk a little bit about that, and we're going to discuss some other issues so that you can, as a team, at the end, like I said before, go back, take this information, get together as your team, and say, okay, how are we going to solve this problem in our community? So to begin this presentation, what we'd like to do is just a brief overview of the safety model for maybe those of you who are not as familiar with it as others. And the safety model is all about determining whether or not a child is safe. So the outcome is a safety decision, and there are several things that are looked at in order to come to that safety decision. The first thing that we look at are the safety threats, and there are two types of safety threats. There's the present danger, which means it's happening now. It's not in dispute. Everyone knows it. There's broken bones, bruises, you know, something in your face. It's happened. We know it. Or there's something that's called impending danger, that it may not be happening right now, immediately, but we know, given the circumstances of the family, that it's likely that there's going to be harm to the child. In your packet, we've presented some helpful little sheets, I think, for you. One is a kind of a square-looking thing called the 16 safety threats. This outlines what those 16 safety threats are. And this afternoon, when we do the more in-depth session, we're going to have you actually working with those 16 safety threats. We're going to give you a case, and we're going to ask you to look at the case and determine what you think are the safety threats. Okay? Jan, did you have anything to say about the safety threats?
Not at this point. Go ahead.
Okay. Second thing we're going to be looking at in order to make that safety decision is the protective capacity of the parent. Now, immediately, you're looking at is the parent able and willing to protect the child? That's the immediate assessment. But as you've said, the more in-depth protective capacity assessment to see what is really going on with that parent takes a little bit more time than that immediate decision. The third thing that we're looking at is the vulnerability of the child. If there is a safety threat, and if the parent is not willing to protect or capable of protecting, is that child vulnerable to the safety threat at that time? And just to give you an example of that, let's think about a 9-month-old. And this is a child who's crawling around on the floor. His mother is asleep on the couch. The child is crawling around in broken glass and cat feces. Mother's not awake to watch the child. Is that child vulnerable at that point in time? I think almost everybody would agree that that child is vulnerable. What if it's a 15-year-old? Is that child vulnerable to those conditions at that point in time? Probably not. He could sweep up the glass and take care of the cat feces himself. What if the 15-year-old is developmentally delayed and acting at the age of a 4 or 5-year-old? Could he be vulnerable to that threat? So the child vulnerability has an impact on the safety decision as well. Mm-hmm.
Are we only considering their physical vulnerability, or are we including their mental?
The
I would
emotional.
think that a mother who is spaced out and they have this problem, I mean, any home that has cat feces on the floor and broken glass, there's problems. So I would think, are we?
But is it a safety threat? There may be a problem, but is it an immediate safety threat? I think that one of the trainers gave an example of, say that mom drinks, and we know that every afternoon she drinks, and about 3 o'clock in the afternoon, mom is always passed out. And this is about the time that the child comes home, okay? What if dad is checking in with the child every afternoon and is talking to the father and is talking to the child and saying, are you home? Is everything okay? Have you done your homework? And checking in, there's a neighbor coming in. Is that child as vulnerable to that as maybe a 15-year-old who comes home, sees mom passed out on the couch and says, party, and goes running and getting the alcohol out of the cabinet and calling over her friends over to have a big party? So there is an emotional part of it in there as well, but it's a critical decision-making process as to whether or not it's a safety threat. So the safety threats are pretty cut and dried. You want to talk a little bit about the protective capacities at this point, Jen?
I will. As Sherry alluded, there are actually 2 different parts to the protective capacities. First of all, within the CPS assessment, we look at a parent's willingness and able to protect. And within that, we look at their adult functioning, their general parenting practices, particularly their disciplinary practices, to understand how the parent manages with this child and whether there are things about the parent's behavior that are insufficient in some way to protect the child. Then we go into a more in-depth assessment of parental protective capacities, which serves as the basis for developing our expected outcomes, our services, all of that. We are looking at cognitive, behavioral, emotional aspects of the parenting of the parent, and what we are looking at is where there are diminished protective capacities that result in things being out of control, unmanageable in the home, where things have led to the child being unsafe. So we're looking not at general kinds of things about, does this parent work, do they seem to love their child? We're really looking at what is it about this parent that has led to their child not being safe. And that's what we want to change. That's what we want to work with the parent on changing. We also want to be sure we identify strengths that the parent has. Most parents do have some strengths, and we want to understand and recognize those because they often provide us a basis for working with the parent. So we want to increase those protective capacities that are diminished in order to lower the risk to the child.
And when you're determining the child vulnerability, there are also some things that you can do to lower that vulnerability. For instance, if the child is isolated, you can increase the visibility or access to others or to neighbors, increase supports to the parents, provide services to address any emotional, developmentally, or behavioral needs that the child may have. You can also, when you're looking at returning the child, you can look at reducing the child vulnerability by maybe reunifying the children one at a time rather than all at once. Or you can, while a child is in care, try to decrease the number of placements, because we know that the more placements that a child has, the more behavioral problems that they're likely to develop. So there are a lot of things that you can do to address child vulnerability as well. So with that brief overview of the safety model, what we'd like to do now is look at the dependency hearings and look at them one by one and talk about what the court needs and what the court has to do at the hearing and what child welfare is doing at that particular time. And you'll begin to see some of the issues. So at the shelter hearing, the court first needs to make a reasonable efforts finding. They need to see if the agency made reasonable efforts or active efforts, if it's a Indian child welfare case, to prevent the placement, to prevent the children having to come into care. They also need to look at the best interest of the child. They need to look at whether or not the petition is legally adequate and whether each parent is addressed, not just the mother, but is the father addressed in the petition as well. Has the Indian Child Welfare Act been determined? What is the agency, what information can the agency bring to the court in order for them to make that determination? Then they need to determine whether there's probable cause or not, and whether or not temporary custody should be given to the agency. They need to appoint counsel. They need to do any restraining orders that may need to be put into place. They might appoint a CASA. And they need to make the placement findings as to whether or not diligent efforts were made to place the child with a relative or someone who has a caregiver relationship, is the way it is in statute. And they also need to address visitation. So they're looking for information in order to do these things at the shelter hearing, which happens 24 judicial hours after the child is brought into care. Judicial hours, for those of you who may not know, is time the court's in session. So if the child is brought into care on Thursday, should be into court on Friday. But if the child is brought into court on Thursday and it's Thanksgiving, the court may not be until Monday of the next week. So whenever the court is open, 24 judicial hours, we need to do this shelter hearing.
And on the child welfare side, obviously we're very busy in that first day. We're out making contact with the family, with the child. We need to make an initial determination about whether we have an unsafe child or not. Often at this point we're focusing on an extent, nature of maltreatment, history of previous maltreatment, things like that. We're certainly making an initial assessment of a parent's willingness and ability to protect. And if we think we need, at least at this point, think we have an unsafe child, we're determining whether we can put in place an in-home or an out-of-home plan. We certainly need to determine if there are other children in the home who are not safe, and certainly to put in place a plan for them as part of that. If we need to place a child, we need to get a visitation plan set up. ICWA, obviously, as Sherry alluded to, we're starting again to identify legal parents and begin search for relatives, others with caregiver relationship. Our focus again right now is just in this initial look. Do we think this child needs to be protected until we can continue and do our thorough assessment? So think something's going on here, need to make sure this kiddo is safe until we complete our 30-day, our complete assessment.
Okay, the next hearing that happens, and this doesn't happen in all counties, so I'm not sure how all of your counties operate, is the admit, deny, or settlement conference. I don't know if you have those in your counties or what you call them. Any feedback? Okay. This is the time when we're looking at whether or not the parents are admitting to the allegations on the petition or whether we're denying them and maybe going to a jurisdictional hearing. At this point in time, there is an issue that we've identified that arises in that a lot of time in settlement conferences, there is some discussion about how we're going to word the petition and what the action agreement may be, what services could happen, maybe whether or not there need to be safety services in place, or what are the conditions for return. If it's going to settle at this point in time, which is 30 days into the case, there has to be a whole lot of information available. The other point that becomes a problem here is that according to the safety model, a safety threat is non-negotiable. It either exists or it doesn't exist. So trying to plea bargain in the criminal arena language around those issues becomes very problematic. The next thing that happens also at this point in time is completing discovery. And often, as you'll find when Jan talks, child welfare is not in a position to give us that discovery at that point in time. So Jan, what's happening in child welfare?
Well, we have within 30 days to complete the CPS assessment. That means collecting information in what we're calling the 6 domains or the family functioning assessment. That means continuing to look at extent and nature of maltreatment, history of maltreatment, things like that. Collecting better information about the child's vulnerability, really getting in depth at the emotional, developmental, as well as the physical issues that the child may have that affects their vulnerability to the safety threats. Looking in depth again at parents' willingness and ability to protect, how they function as an adult, how they parent in general, how they discipline, all of those things that speak to their relationship to their child or their children. All of that information then we pull together to make a final decision about whether or not we have a safety threat. At that point, if we think we have a safety threat, we're going to move to what we call a child safety meeting. That meeting is intended to bring in extended family, community supports, whoever we think could be helpful in developing what we hope can be an in-home safety plan for the child. We may not be able to get the child home at that point, but if we're not, then we really need to be looking at what are the conditions for return, what needs to be in place in that home for that child to be able to return. And we also take the information we've collected so far and start on the protective capacity assessment, that in-depth look at parental functioning. Again, we continue with our visitation planning, assessing sibling issues, looking for absent parents, particularly dads. whatever. I guess usually it's dads, but sometimes we have moms, continuing relative search, all of those kinds of things. We also are at this point responsible to get a mental health or early intervention evaluation done for the child. So that's what the work is at this point. We're also at 30 days. Depending on the county you're in, we're often looking at transferring the case from the CPS to the ongoing worker, who will at that point take up responsibility for the ongoing safety planning of the child.
So if the case is not settled, then we're going to have a jurisdictional hearing, and at that point in time the court is going to need to have sufficient information in order to determine whether to take jurisdiction or not. And they also need to determine whether allegations are sufficient to support what type of intervention. Does this need to be an in-home plan, or does this need to be an out-of-home plan? And they're making the reasonable active efforts finding. We made a chart for you that's in your materials. If you go to probably about page 14, I think, where we've listed the jurisdictional basis, what the court statutes say that the court can take jurisdiction on, and kind of tried to lie the safety threats next to them. Again, this is the language issue where we're not all speaking the same language. But if you look at those, you can see that there is a relationship between the safety threats and how they can fit under one or another of the jurisdictional basis.
So 30 days, we now are likely to have an ongoing worker who is responsible for continuing to review, monitor, manage child safety. If the child's in care, they're looking at conditions for return and whether those are being met. If the child continues in care, obviously they're continuing to work on visitation planning. They're completing the protective capacity assessment, which will lead to development of expected outcomes, which is, the expected outcomes are intended to be a statement of the behavioral change the parent needs to make in order to be able to protect their child, to safely parent the child. Based on what I should go back and say, you know, protective capacity assessment has these specific outcomes around what needs to be enhanced, what's working well already, but the protective capacity assessment is also a process by which we're working to engage parents. Our job as social workers, as caseworkers, is to find ways, if we can at all, to work with the parent, to motivate them, to help them make change. So I just want to emphasize, this is not us making decisions sitting at our desk saying, that are based on information, I think the parent needs to work here, this is a service they need. We need to be out talking to them, working with them about what it is that needs to happen for them and their families. So we're going to look at what it is, which protective capacities they need to work on improving, what changes they need to make behaviorally, that's the expected outcomes. And from there we will work with them on what services are going to help them make those changes. And that's what goes into our action agreements. It isn't until that point that we really start to talk about specific parents or specific services with the parents. We also, if the child's in care, have the Oregon Family Decision Meeting. Statute requires that we consider, we certainly encourage our staff to have that. This is an opportunity, again, for us to engage extended family members in planning for their child. As Judge Orff alluded to earlier, we are seeing and will continue to see a very strong push for early and continued engagement of extended family, because research is showing us that that's where children, if they can't be with parents, that's where they do best. The Oregon Family Decision Meeting is intended to involve that extended family in planning for their child, in developing resources, in potential placement, and helping us to develop the concurrent plan for the child.
So after jurisdiction comes disposition, and usually or frequently these happen at the same court hearing. You wouldn't even know that there was a difference between the jurisdictional hearing and the dispositional hearing. At disposition, after the court has determined whether or not the child will become a ward of the court and has made the reasonable or active efforts findings, They're going to approve the concurrent and current plan. And here we have an issue because defining the case plan has been something that's been very difficult to do since DHS may not even have developed their case plan at this particular point in time. Then we have to, the court is reviewing the placement as to the diligent efforts to place with relatives and the appropriateness of the placement. They're looking at the visitation plan so that they can determine whether or not the visitation plan should be ordered, determining family involvement, and ordering services for the parents and the child. Now, the services need to bear a rational relationship to the basis of jurisdiction. And one of the things that has already been pointed out by one of the members of the audience here is that it becomes a difficult thing to order services when the agency is at this point in time looking at expected outcomes. So for instance, the expected outcome in a domestic violence case may be that the mother understands the harm that the domestic violence has had to the children or the effects that it's had on the children. That could be accomplished through a number of different kinds of services. The agency is looking at the outcome. They're looking at the change behavior as opposed to the services. It may be that a batterers intervention group will help, or that a domestic violence group will help, or it may be that some kind of counseling will help. It could be a number of services that could get to that expected outcome. And the court is also at that hearing needing to order DHS to make referrals, setting the date of achievement, and maybe reviewing the conditions for return. Here's another language problem that we sometimes have. The conditions for return do not mean that the expected outcomes have been met, that they have been accomplished. The conditions for return means how can the child safely live in the home while the parents are continuing to work on their changes in behavior that need to be made.
Well, I think we've had difficulties with some of our community partners understanding when we develop those conditions of return and work solely with the family without involving, at the child safety meeting, so they're like, well, you've already made these decisions without us, and I was just wondering if you could clarify the difference between a child safety meeting in Oregon.
Family decision meeting.
Yeah, just for the community partners that are here, so they understand why we are engaging the family in getting their kids home, why that child safety meeting is structured the way it is.
Yes, I will do that. There are two different stages that we're at in the case. Within the child safety meeting, we're trying to figure out what's it going to take to keep this child safe. And we're involving family members. There are times when we may include community partners because they're going to be safety service providers. I think about the teacher at school that the child's going to check in with, perhaps being a provider. But the intention is with both those meetings that we are going to involve, and I want to stress extended family. Sometimes we talk family and we just are thinking parents. We're really looking at grandma, aunt, uncle, cousin, whoever we can gain access to that we think can help us put in place a way to keep this child safe. Safety is different than change in parental behavior. If we have enough people checking in at critical times in the home, we can put in place ways to keep that child safe while the parent is continuing to engage in whatever services are going to help them make the changes that they need to. We'll go back to the mama drunk on the couch. If we have somebody there in the morning making sure that kids up, getting dressed, gets to school, teachers checking in at school, making sure the kiddo's okay, somebody's there in the afternoon when child comes home to make sure that if mom is passed out, child is getting what they need when they get home. Either that's they're calling to check in on their dad, which is one thing we described, or the 9-month-old, if they've been at the daycare center, is that the house is clean, that the child's being taken care of, they're being fed, things like that. That's all part of making sure that the child is being sufficiently and adequately cared for. So ideally, mom's no longer on the couch, she's up, she's going to AA, she's doing whatever she needs to do in treatment. I mean, I think that we need to also recognize that we have a parent who is willing to be involved in services, is willing to have an in-home plan, is engaging in and is committed to making the changes that they need to. So that's part of what we're looking at in an in-home plan. So I got it. Sure.
Real quick, Jan, because this came up yesterday because what I had happen a couple of times to me last year was that child welfare, trying to do the safety plan, wanted to send child home even though parents had not completed services, but they also asked that I dismiss jurisdiction, and I wouldn't do it because I felt the case needed to be monitored until at least the parent completes services and perhaps demonstrates some period of follow through. So there's a tension there. And then just to put in the other biggest tension that we got into in Jackson County was this one, that courts doing disposition under ASFA no later than 60 days from time of removal, and we're often setting cases 45, 50 days because of the crunch in the calendar and trying to get all these cases heard within ASFA timelines. And then here child welfare is doing action agreements and case plan maybe not until 60 days after the disposition. That does not work for the trial court. It does not work for the Court of Appeals. We have to have that information at disposition, or we're possibly going to look at having this case reversed on appeal. And so there is one of the real rubs, and we're encouraging you to meet in your model court teams and have that discussion locally, and hopefully we can come up with best practices from all the model court teams about how to handle this tension. Thanks, Sherry.
Yeah. Going back to our mom that's asleep on the couch at passed out 3 o'clock. The difference between the safety plan and the expected outcomes is that the reason that the house is a mess or the mom is asleep isn't the true safety issue. I mean, you can clean up the floor, you can pick up the cat feces and say that the safety concerns are gone, but they're not, because it's really what's behind the behavior that's being exhibited at what the agency is trying to get to with their expected outcomes. What are the causes? Is it the mom's mental health issues that are getting in the way? Is it her medications? What is it that's causing the behavior that's creating the immediate safety threat? So you may be able to mitigate the immediate safety threat and have met the conditions for return and send the child home with all of these services being put in place, but the parent still needs to meet those expected outcomes before the case can successfully be closed by either the court or the agency.
Questions about that before we go on? Okay.
Okay, 6 months from that, we have either a court review or a CRB review. And at that point in time, the information that they need to do is to look at what kind of progress the family is making, and is it sufficient progress. So again, we're looking at change versus compliance. It's not that mom has gone to 12 parenting classes. It's what has she learned during those parenting classes, or what has the change in behavior been. We're looking at whether or not there's a continuing need for placement. Have conditions for return been met? The court needs to review the agency's reasonable or active efforts and to see whether the agency is in compliance with court orders and their case plan. The court is reviewing the plan and the concurrent plan and making any adjustments, and making findings regarding visits and placements and schools and DHS contacts, a lot of those kinds of things, and need all of this information from the Child Welfare Agency in order to make those findings, and looking at the likely date for return. And we'll go in more specifically to all of these things in the afternoon session.
The only thing I would add, I mean, we're obviously busily preparing that information, assessing what's going on in the case. I think the key point for us here is that we are balancing, continuing to balance what is the least intrusive but still sufficient safety plan for the child on the one hand. Are we getting anywhere to being able to return the child home with changes in the parental protective capacity? So those are three pieces we really have to, they each impact the other, and we have to really analyze how they're all affecting each other. Go ahead.
The next major hearing is the permanency hearing. The court at this point in time needs to determine the permanent plan, needs to review the family's progress in order to do that, and the agency's reasonable or active efforts. The court needs to consult with the child in an age-appropriate manner, and Becky's going to give us a brief talk about that. The court needs to determine whether we're going to return to parent or move to the concurrent plan. If we're going to return to parent, is it going to be now, or is there going to be an extended time for that, and what is that time and what needs to be accomplished during that time? Maybe looking towards the 15 to 22 months finding, making compelling reasons findings, and reviewing the comprehensive transition plan for youth that are 14 years of age or older.
And I think pretty much we're at this point moving into our case plan reviews, looking at sibling relative issues. We're really starting to look at the concurrent plan for the child, adoptability. If we have a child over 14, we're obviously looking at involving them in their decision making. I'm sorry, and I appreciate your telling me. I have been told I have a quiet voice, so that's good feedback. I'll do my best. We're also getting into the area of the case that I'm less familiar with, so you'll notice I'm reading my notes more probably. At any rate, we're moving to making a long-term final or permanent plan for the child in terms of their adoptability, what family resources we have, whether we need to be working with siblings, things like that. So that's where we are on our case plan side. I would say that if we've done a good job with developing expected outcomes, we also have good information about why this parent is not able to adequately parent the child.
Okay, and then we go on with hearings, CRB or court review every 6 months thereafter, and a permanency hearing every year thereafter. So I think in this discussion of looking at the timelines, you can see where some of the inherent bumps are, where they don't quite match up together. What we would like for you to do when you go back to your local communities and meet in your teams are to consider these issues. What is your minimum standard for information? What information do you need to have for the court in order to make the determinations that they need to make? And do you use that information to make the decisions, or do you focus primarily on the allegations of maltreatment? Again, looking at the overall case plan rather than just the initial specific safety issue. Do you have clear definitions and consistent criteria for making the decisions? Is safety confused with risk? Again, once the safety threat has been alleviated, can the conditions for return be met? Is there still risk? Maybe, but where on that continuum of risk to safety do you fall in your community on when the conditions for return can be met? Are safety plans confused with case plans or expected outcomes or action agreements? What are all of those things, and how in your local community do you need those things to be structured and to look at them? Do you have any home safety plans? Is a safety plan only seen as a placement? Because if a safety plan is grandma being there, is that going to be sustainable over time? Is reunification achieved when safety in the home can be controlled rather than when all of the treatment issues are resolved? And does court jurisdiction terminate when the children are safe, or does the court continue to be involved? So these are just some of the issues to start your discussion. We'll be going into all of this much more thoroughly in the afternoon session.
Naturally, I have a question. We had a training a few weeks ago about location of relatives.
Uh-huh.
That was quite interesting, and we walked away from it. The only thing that stuck in my mind was, if you're going to get on the computer and find second cousin, first time removed, who lives in Chicago but is interested in this child, how does that work with the caseworkers, with the time involvement, with all that would go in to that actual turning up a willing relative off here that nobody knew they had?
To be perfectly frank, we don't have the resources, the tools, or the capacity to do what is ideal. We don't. And if I don't get parents at the very beginning of a case to give me a thorough record of all relatives, then I'm screwed. Grandparents are like, I don't want to get involved. I'm not gonna, I don't want to announce to my sister, great Aunt Helen, that my grandchildren are in care. Even cooperative relatives put up barriers. And so I'll get a relative search form that has 1 or 2 relatives on it. Now I hand it to somebody who sends a form letter to those relatives, because I'm spending my time trying to engage that parent, do the protective capacity, work out simply, there are just too many tasks. So I really think it's an area in our agency that if we're gonna start focusing on, we need, in a time of limited resources, we need more resources for it.
It can be done. I'm part of the Casey team. There are 8 pilot counties throughout the state. I'm the leader of the Tillamook County team. I actually live in Tillamook County. And we've been working on relative placements. We've done a family finding training. We've done the family finding for a child. We've done the engaging of the relatives. So it can be done. It's a whole other training other than what we're here today to talk about. We are going to talk a little bit about relatives. That's the next section on section on your thing. But I'd be happy to talk to you during a break or afterwards about some of those questions that you raised.
Well, I think your statement was you had a whole group of people, and what she's trying to say is it's nice if she could turn it over to you and you did all the work.
Who we turned it over to was our Commission on Children, our families, our CRB members, and our CASAs, who formed a team that did this, and all of you have all of those people in your community.
Well, and
so
the point of the Oregon Family Decision Meeting is if you get the family together, they can take on a lot of the responsibility too. There are some family members who are reluctant to be involved, and there are certainly dynamics, but when you look at the national resource, it is family group conferencing, family decision meetings that really have the largest impact in getting family together to plan for and take responsibility for their child.
And I do want to say that the CASAs and CRB gave me a great training on the importance of involving family. It was wonderful. They provided web sites that you can pay to get on to find family members, but in a rural practice, I don't have the ability to pay, unless I go home and pay for it on my home computer, and so, I just want to reiterate, there are some glitches between.
Let me just tell you, in Jackson County, through the Casey Initiative and some other grants, there was a project started called Reconnecting Families that the CASAs are primarily taking on, and it came through the Commission on Children and Families as well, to set up people whose jobs were to locate relatives. And so one of the things with model courts is maybe we can start sharing some of these ideas about how to get resources, because it does, I think, take a person to be able to do this well. So we'll talk more and trade information.
I'd love to do a whole training on this, because I'm a relative who's raising 2 children as a relative, and I really believe in the importance of that. I know when I got that initial letter in the mail saying you have a relative in care, please contact us within 14 days to tell us whether I hadn't seen my brother in maybe 5 years. He had been in and out of prison. I was not immediately jumping on the bandwagon to become, so there are barriers, but they are workable, and family members are our greatest resource. I think that's our session.
Right, so
Time
let's
for a
take a
break.
15-minute break. And I know we're running a little behind schedule, but basically